is submission and undertaking placed on record. Hence, released on 14/11.
Let my letter going below the other respondent.
Symbol 5.
It is up to him if he wants to join, let him join. All these matters. 3, 5, 6, 7, 8,
7, 8, 9, and 10.
10. Next.
Symbol 11. LPA 278 of 21.
Aditya Bhatt. By the first respondent. You have not taken steps. Which came to be decreed by judgment and decree dated 31/12/2012. The said appeal, being agreed by the same, appeal was filed by some of the defendants in civil appeal number 21 of 2014 and 22 of 2014. Extent of as sought for (18/20, 2014). same, SCA 3040 of 2016 was filed, which also came to be dismissed, and as such, LPA 278 of 2021 has been filed, had been filed. The jurisdictional court adjudicating regular civil appeal 21 of 2014 and 22 of 2014 along with regular civil appeal 18 of 2014 to hear and dispose of the same on merits by observing as under extract paragraph 6 of the order dated 2/9/2022. We had also directed the jurisdictional court to hear the appeals on day-to-day basis and dispose of the same expeditiously and at any rate on or before 30/9/2022. Of course, subject to the learned advocates appearing for the parties cooperating with the court below. We had also reserved the liberty to the appellate court to regulate its proceedings by putting the parties to terms and impose exemplary costs on either of the parties in the event of any unjustified request for adjournment is sought for. Full stop. Now, a communication has been received from the second additional district judge Jamnagar by the registry forwarded and placed on record. A perusal of the said communication would indicate that at the drop of the hat, adjournment has been granted. Parties have not been put on terms. It would also disclose that way back in the year 2014-15, some of the parties had expired, and we say so for the reasons indicated by the learned judge himself. Full stop. Though we had given liberty to the learned judge to impose exemplary costs for reasons best known, no cost seems to have been imposed. The parties themselves have exhibited laxity, uninterestedness in prosecuting the appeal, and as such, by reiterating the directions issued by this court on 2/9/2022, we extend the time till 31st December 2022 to conclude the proceedings, if necessary, by observing. If necessary, the learned judge would be at liberty to pass such orders, either placing the learned parties ex parte or arriving at a conclusion that the proceedings against the dead persons having abated by virtue of some of the parties having expired way back in year 2014 and 15, and their legal representatives having not been brought on record till date, and no application for setting aside the abatement also having been filed. In other words, by operation of law, the appeal against the dead persons have stood abated. Hence, it is for the learned appellate judge to pass appropriate orders and dispose of the appeals itself within the time frame fixed herein above. Registry is directed to intimate this order forthwith by email and by speed post to the jurisdictional court.
Number 12, civil application 12 of 19.
Please, Manoj. Now here, this is a leave to appeal application. There was a common order passed in 5 matters by the learned single judge, but the order was transcribed in only 3 matters. For 2 matters where order was not transcribed, because in one of the matter, your lordship had directed the registry to place on record the original file. Can I just pass that? This is a cognate matter.
In this matter,
This matter is cognate to this matter. That was SCA 12612. This is SCA 12611. Now here also, if your lordships have the order of the learned single judge for a minute, means I'll tell your lordship what the problem has arisen for us. Kindly see the order at the top. Your lordship would find 3 SCA numbers just after the memo of appeal. It is 12609, 12610 and 12613. There were 2 cognate matters, 12611, which is the present LPA arising out of which the present LPA is arising, and 12622, which are not mentioned here. But those appeals, those petitions are shown to be disposed of and allowed by the same order in the status report. May I just show the status? Yes.
where is the order?
But the appeals are the matter is shown as disposed. Therefore, the lordships have directed that the original record of SCA should be placed on record. So in same
Post
order.
this matter, registry is directed to put up the original record of SCA 12611 of 2006 and release this matter along with CA 10 of 2019 in LPA 37119 of 2018.
Filing number, LPA filing number.
Filing number, F number, with LPA number 37119 of 2018, F number so and so. In SCA 1261, in SCA 12611 of 2018. When is the next date for this?
No, that matter was not thereafter. Lastly listed on 3rd October. Thereafter, it has gone in cutoff. So we are also to make a request that that matter may also.
No, this was supposed to be listed
Yes.
on 13/9.
13/9. Then it was adjourned to 3rd of October.
Ah,
After 3rd of October, it is not showing any. No date is showing.
release this matter on 212,
Please, my lord.
along with the above referred matters.
Please, lordship. Like,
Number 13, SC 23053 of 70.
Your Lordship, I take up 21259, 21529. Lord, there are similar matters, all of them. Lord, this is the first matter which was filed, and that's why I'm requesting that this may be taken up. Lord, these arise in respect of drug price control order of 2013. And we have challenged in this petition, the Lordship may see page 23. Quashing and setting aside notification dated 10/7 to the extent it fixing its maximum retail price contains 5 milligrams show cause notice dated 15/5 and demand notice dated 11/8. Now, my lord, if your lordship would have a look at the order which is under challenge, it is at annexure T. Lordship will require a drug price control order 2013. Extra copies. Incomplete. એટલા માટે. These are orders passed under the Essential Commodities Act. Your lordship may have a look at the relevant provisions before I take your lordship to the impugned order. Provision is para 19. Para 19 of the drug price control order. Notwithstanding anything contained in this order, the government may, in case of extraordinary circumstances, if it considers necessary so to do, in public interest, fix ceiling price or retail price of any drug for such period as it may deem fit. And where the ceiling price or retail price of the drug is already fixed and notified, the government may allow an increase or decrease in the ceiling price or the retail price as the case may be, irrespective of the annual wholesale price index for that year. Now, this applies to drugs which are not within the price control, outside the price control, but the government can at any time fix the prices. Now, my lord, what it can fix, if your lordship would have a look at, fix the ceiling price or retail price, both of which are defined in the provision. Your lordship may go to the definition.
Yes.
Para 2, clause D. Ceiling price means the price fixed by the government for scheduled formulation in accordance with the provisions of this order. Well, I'll take your lordship to the relevant provisions of ceiling price in a minute. And retail price is 2Z, means the price fixed by the government for a new drug. And new drug is also defined in clause U. We need not go into that. New drug under paragraph 5. Now, the ceiling price is under paragraph 4. The ceiling price of a scheduled formulation of a specified strength and dosage as specified under the first schedule shall be calculated as under. Step 1. First, the average price to the retailer of the scheduled formulation shall be calculated as below. Average price, sum of prices to retailer of all the brands and generic versions of the medicine having market share more than or equal to 1% of the total market turnover on the basis of moving annual turnover of the medicine divided by total number of such brands and generic versions of the medicine having market share more than equal to 1% or total market turnover on the basis of moving annual turnover of that medicine. So that will result in the average price of all the brands. 2. Thereafter, the ceiling price of the scheduled formulation shall be calculated as under PC equal to PS multiplied by 1 plus M upon 100, where PS is the average price of retailer, which is the earlier portion. That is how it is calculated. And M is the margin of the retailer and its value is 16. This is how ceiling price is calculated. Retail price is under regulation 5. So under rule 19, even if it is not a specified first scheduled drug under this act, government can fix the price. But what it can fix is either the ceiling price or a retail price. Lordship may again go back to regulation para 19. Ceiling price or retail price.
Yes.
It cannot fix maximum retail price. That is not within the powers of the authority. If your lordship would go to the definition of maximum retail price, it is under 2R.
Yes.
Maximum retail price means the ceiling price or the retail price plus local taxes and duties as applicable. So the order contemplates either you fix a ceiling price or for a new drug a retail price. And the maximum retail price in that situation would be the retail price plus taxes. So a retailer would be able to, if it's a retail price is fixed at 10 rupees, then the retailer would be able to sell it at 10 rupees plus say 20% tax, 12 rupees the drug, particular drug. This is what is contemplated. Rule 19 does not ever contemplate fixation of maximum retail price, because maximum retail price is dependent upon the local taxes from time to time. However, the impugned order fixes the maximum retail price. So this is the first ground of challenge. Your lordship would go to page 25. Page 25 is the impugned order. Passed under paragraph 19.
Yes.
Para 6, para 9 at page 26.
Yes.
And whereas NPPA has considered this matter in detail at its 1747th meeting held on 16/5/2014 and approved objective guidelines for fixation oblique revision of prices of non-scheduled drugs. This is not a scheduled drug. Scheduled drug will fall under para 4 or 5.
Where are reading, Mr. Mayor Thakur?
Para 9
9.
at page 26.
Hmm.
Has considered this matter in detail at its 1747 meeting held on 16/5/2014 and approved the objective guidelines for fixation oblique revision of price of non-scheduled drugs showing extreme inter-brand price difference under para 19 of DPCO. It has decided to start with inter-brand price variation will be whenever the maximum retail price of the brands of medicine of a particular formulation exceeds 25% of the simple average price, the same will be kept at 25% level. Now, para 11. Whereas the National Pharmaceutical Pricing Authority monitors the price of decontrolled non-scheduled formulation on regular basis, and wherein from the data obtained from IMS Health, it was observed that the prices of simvastatin tablet in the strength of 10 mg, 20 mg, 40 mg, and 5 mg, manufactured, marketed in brand name by respective companies, namely USV, MSD, Stancare, Cipla, Lupin, were found exceeding the limits of simple average price of medicine plus 25% as per the market-based data provided by IMS Health for the month of 2014. In accordance with the guidelines issued by NPP after approval of the competent authority in respect of price fixation of non-scheduled formulation under para 19 of DPCO, prices of such formulation as specified in the table manufactured marketed by the above mentioned companies were just unjustified and against public interest, as much as it puts an unreasonable burden on the This is what is fixed is maximum retail price, including excise duty and local taxes. There is no power under para 19 to fix this maximum retail price. there is a subsequent notification applying it to all the companies. The same this year. This was applied to the following companies. Immediately thereafter, it has been applied to all the companies. One page only. We'll place it on that.
Yes.
Now, my lord, the challenge to the order is on account of this particular thing, that they have no power to fix the maximum. They could have fixed the retail price, but maximum retail price depends on the local taxes, and that could have never been fixed. So this is the contention on the challenge to the order. Now, this petition is for admission at this stage.
Not after 2005 years.
Yes.
Now we are disposing it for final.
Well, then your lordship may take it up for final hearing. I have no issue, but it is technically for admission. Therefore, I was putting it as propositions for the purpose of admission.
For proposition of final hearing.
Well, then,
2017, now we are saying admission.
Well, I'm not saying no.
Any other point involved?
Well, a lot of other points are there.
Canvas.
Well, I have no problems of canvassing, but it may not be over today.
We will, as far as whatever is possible, we'll do it.
Fine. Otherwise, we can take it up immediately on the first day.
We'll continue from where you have stopped.
Certainly. This is the first contention which I'm raising.
Yes.
This is the challenge to the order. The second contention which is being raised by us, perhaps not in these petitions, but the remaining petitions, is the virus of para 20, subpara 2.
Approval?
Well, para 20, subrule 2, subclause 2. Manufacturer shall be liable to deposit the overcharged amount along with interest thereon from the date of increase in price in addition to the penalty. Now, my lord, under the provisions of the Essential Commodities Act, interest has to be from the date of the order. Therefore, this particular provision is contrary to Section 7A of the Essential Commodities Act.
Section 7A.
7A. I'm sorry, it is section 7. Section 7A, make any default in paying or depositing the whole or any part of such amount. The amount in respect of which such default has been made shall, whether made on or before the commencement, and the liability of such amount paid person deposit be recoverable by government together with simple interest due thereon, computed at the rate of 15% per annum from the date of such default to the date of recovery of such amount as an arrears of land revenue or public demand. So it arises from the date of default.
Section 7?
7A.
A.
Capital A. Together with simple interest due thereon, last line of subpara 1.
Read 21, 22 once again.
22.
Oh.
The manufacturer shall be liable to deposit the overcharged amount along with interest thereon from the date of increase in price in addition to penalty.
In addition to the penalty.
Yes, in addition to the
So penalty is something which is...
No, I'm not on the penalty. I'm on the interest.
No, not on the interest. There's anything charged excess. Suppose your price, maximum price is
10 rupees.
10 rupees. You
And
charge 12
12 rupees, then on 2 rupees, I am not only liable to pay penalty, but also interest.
Correct.
That is the provision.
Penalty is something different.
Penalty is something, I'm not on the penalty.
The 2 rupees addition with interest,
With interest.
you will have to deposit.
Yes, undoubtedly, but from which date? Now, Lord, here the provision is from the date of increase in the price.
Correct.
Now, the provision in section 7A is 15% per annum from the date of such default to the date of recovery.
7A is referable only to penalty.
No, my lord, it applies to any amount to be deposited.
Now, if they don't say anything, suppose the order says that excess amount also you pay as per the order passed under 7A read with section 3. You are right.
Therefore, I'm on the excess amount only, not on penalty.
Correct. You show us the order where an order has been passed, that excess amount is also to be paid.
I'm coming to that. I'm just showing these are the
virus challenging is something different. On facts is something
My
different.
lord, I'm coming to the facts immediately. Your lordship could go. Now, my lord, with this background, your lordship could go to the facts. This notification was issued. There was a challenge before the Bombay High Court to this particular order.
Which order?
The
Control order.
control order, the order dated 10 July 2014, which petition came to be dismissed. Your lordship would have a look at the order dismissing the petition, which is at page 60.
Page
60. Page 60 is the division bench of the order of the Bombay High Court. Your lordship may go to page 65. The arguments before us focused only on the understanding of the parties of para 19. Your lordship has got para 11,
Para 11.
page 65, para 11.
Yes. Yes.
For the purpose of this para, the guidelines have been issued, and according to the petitioners, they guide the exercise of powers in terms of para 19 of the DPCO, so far as they empower fixing of price of non-scheduled formulations for a specific period. Para 2 of the guidelines is referred to in para 8 of the writ petition, and a copy of the entire guideline is annexed at Annexure D. The petitioners are therefore aggrieved and dissatisfied with the exercise of powers by the respondent number 1 to 3 and the para 19 of the DPCO. According to the petitioner, respondent number 3 has issued 33 notifications and orders, all dated 10 July, and has arbitrarily fixed a maximum retail price, including excise duty, local taxes, and anti-diabetic cardiovascular, that is impugned. The essential contention before us is therefore that the extraordinary circumstances in terms of para 19 are determined by these guidelines. That para 19 opens with a non-obstant clause, and the government exercises the discretionary power in cases of extraordinary circumstances, if it considers necessary so to do in public interest, fix the ceiling price or retail price of any drug for such period as it may deem fit. And when the ceiling price or retail price of the drug is already fixed and notified, the government may allow an increase. Ms. Pereira, appearing in support of this petition, firstly contends that the impugned orders are based on an erroneous interpretation of para 19. The para empowers the government to act only in extraordinary circumstances, and if it considers it necessary in public interest, it can fix the ceiling price. The extraordinary circumstances must be shown to be existing, and they must be clearly reflected in the orders. Then, my lord, the second contention, para 14. Ms. Pereira has taken us through the guidelines to submit that though extensive affidavits have been filed in reply and rejoinder, now what emerges from the record and post-filing of the writ petition is the latest position indicated in the affidavit which has been filed by the Deputy Director in the office of NPPA. It is stated therein that NPPA in its meeting held on 15 September decided that all pending proposals for price fixation under para 19 shall remain deferred pending resolution of the entire matter by way of court judgment or statutory directions from the government. Later, the said internal guideline dated 28 have been withdrawn and on 22nd September with immediate effect. However, the statement is clarified by pointing out that this withdrawal is prospective. Ms. Parera therefore would submit that once the matter is pending before the High Court of Delhi at the instance of the organization, then in light of thereof, by withdrawal of these guidelines, it is considered that the exercise of powers in terms of para 19 is unguided, unbridled, and unregulated. Lord, the Bombay High Court rejects this contention in page 71. It is not for this court to interfere with the working or functioning of the expert in the field. It can safely be concluded that NPPA is a body of experts. It is guided by para 19 of the DPCO as a whole. So also the constitutional mandate indicated above. The power under para 19, which is discretionary, is coupled with a duty. The extraordinary circumstances and public interest by themselves are guiding factors. And even if there are separate guidelines, which may have been issued but not withdrawn, does not mean that there is nothing to guide exercise of powers in terms of this para. Once the aim and object of DPCO is to ensure that the essential medicines are made available at affordable prices, and the directions of the Supreme Court guide the authorities, and we do not see any substance in the contention of Ms. Parera. And all other contentions were rejected. Ultimately, Lord, the petition came to be dismissed. Lord, SLP was also dismissed at page 77. Post this, my Lord, show cause notice was issued on us, which is at page 28. At page 28, dated 15/5/2017.
28,
Page 28.
yes.
This has reference to the office notice dated 11/1/2017. For your having manufactured, sold subject formulation, Simvastatin 5 tablets containing Simvastatin at a price of ₹97 for 10 tablets against maximum retail prices inclusive of excise duty and local taxes at ₹7.82 for one tablet. Notified under the notification under para 19 of DPCO, the company was directed to furnish quantitative details in respect of the subject formulation duly certified by the chartered accountant. In this connection, it is stated that the price of the aforesaid formulation was fixed and notified on 10/7/2014 under para 19. The company was obligated under the DPCO to follow and implement the price notification from the date of the notification. It may be noted that batch number manufactured in the month of February 2015 was available in the market much after the issuance of notification at a higher MRP of ₹97 for 10 tablets against MRP of 78.20.
All right, Mr. Thakur, the show cause notice was issued.
Yes.
Various grounds they have stated.
Yes, my lord. Well, just your lordship may go straight to para 5.
Paragraph 5.
5. As per PharmaTrack data available with the NPPA, it is estimated the company charged. This is not penalty. I'm only highlighting that. 56 crores in excess from the consumers. 56 lakhs. 56 lakhs.
When Thakur comes, only crores.
In excess from the consumers for the period from July 2014 to November 2016. So this is a differential of the quantum. It's not penalty. In respect of the above formulation, as per details at annexure
That is
1,
difference of price, that 7 rupees to 78 rupees.
yes, that difference in price. And the quantum of goods sold multiplied by the quantum of goods sold. From July to November, in respect of the above formulation as per details in annexure 1, in addition, the company is liable to pay interest on the overcharge amount till its full payment under section 7A of the Essential Commodities Act. 7A is no issue. Computation is not as per 7. The company is also hereby given an opportunity to show cause within 30 days from the date of issue of this letter as to why action should not be taken to recover the overcharge amount of 56 lakhs along with appropriate interest. If the company does not submit the batch-wise production and sales details within a time frame, it will be presumed that the company has nothing more to say. The company was directed to furnish the first batch-wise production details on 10 July to till date duly certified by Chartered Company in 30 days. Then about this, we gave a reply.
All right, we'll continue. Some matters we'll have to take it up.
Yes, certainly. Not on the first day, reopening or some other day. Whatever date your lordship says.
10th.
Well, 10th, if it can be avoided, any other date.
Will not be there.
No, I'm very much sure. Look, there is one contested matter where it was mentioned 2-3
So
times.
this is not contested.
No. Look, there is one advocate who had come and mentioned for a matter before Justice Desai. That is fixed.
Khosla.
Yes. That is fixed. That's why I'm avoiding, because that will take a long time. 11, 9, whatever your lordship says, it's no problem.
Take a chance on 11th.
11, certainly.
Heard Mr. Mir Thakur, Learned Senior Counsel, appearing for the petitioners. For want of time, release this matter on 11/11.
The interim orders to continue. Interim orders to continue. Look, they've been there.
Interim order of Shako's notice.
Not to recover.
No terms. You have not been put on terms. Interim arrangement, interim order made earlier to continue till next date. It has not been extended after 24/3.
Because of COVID, may not possible. COVID, but no action is taken till now. COVID.
You are appearing for whom? NPPA. Perennial litigations of NPP.
Because the same set of notification is again sought to be challenged. But my senior friend contended that this was already subject matter of challenge before the Honorable Division Bench of Bombay High Court. Honorable Division Bench has already upheld that validity of
He has already brought to our notice.
the same as
All right, we'll see. Yes. What is it? Yes, where is my? Tell us. Otherwise, we are passing in tomorrow. Yes.
She's actually on her legs before the honorable.
But take instructions. We are raising. Another 5 minutes we are raising. Otherwise we'll pass orders. We
My-
direct you take,
I'll take it.
allow her to participate here.
I'll take
There
it.
are 2 judgments of the apex court, latest
The one
judgment.
but the one which your lordships mentioned was one presided by Justice Chandrachud is
Both are Justice Chandrachud's judgment.
but she is on her way.
The online which I got the copy of that admissions to the Jamnagar, with my lord's permits. The front page is, my lord, with regard to the authorized colleges of All India Medical. The next page on item 2, your lordships will find in column 2, number 5,57,986, MP Shah College Jamnagar, MBBS, open PWD, general PWD allotted. Now this number 5,57,986, your lordships can verify from page 34. The certificate issued by the Bombay Medical Board. There cannot be two different yardsticks, my lord.
Yes. Petitioner is a spastic cerebral palsy. Petitioner is. Yes, we'll hear. Only we'll dictate the facts. And keep it. Having locomotor disability. Locomotor disability. You are consenting, madam? You are consenting?
Milord, I have just 2 things to point out.
No, on merits, whether you are permitting her to
We would, but I just want to point out something to the Honorable Court. This judgment of Honorable Justice Chandrachud wouldn't be applicable. The reason is that was a question where she did not.
Forget about that. That we'll consider it on at the time of merits.
I have a copy of the judgment. It's on a completely different line altogether.
What is the party's name? Party's name.
2 copies.
Tell us party's name. Tell us. We have got the copies.
Raj Kumar versus Union Public Service Commission.
After that, there is one more. Avani Prakash versus National Testing Agency.
I'll give a copy. So, this is not clear.
We will.
But considering the fact that, the All India Institute of Medical Sciences Board has considered her positively. She falls within the All India quota. In the peculiar facts of this case, the petitioner will be considered. That is my instruction.
Okay.
But, my lord, be noted that, my lord, tomorrow we will have at least, before reopening, half a dozen or more petitions claiming that, my lord, medical board and appellate board reviews examinations in terms of
No,
government
we'll only record that having regard to the certification issued by the,
That is what I'm stating. my lord. We need to make out, let it be
a
restricted.
standalone case.
Standalone case.
The learned GP. No, they take out the petitioner is a spastic cerebral palsy by birth and having locomotor disability. The certificate issued by the Civil Hospital Ahmedabad, Annexure A, would indicate that she is having a
No, it's not a certificate by, I'm sorry, page 34.
no, page 27, madam.
Disability. No,
Civil Hospital Ahmedabad, 50%. That petitioner is having permanent physical impairment, stroke mental ability, 50%. She has been diagnosed for as quote case of CP, C, small c, above that dash in bracket RT,
C with the top up means with CP with right infantile
in infantile
uresis.
hemipuresis, PURESIS, and what is this? Otics G, or
ATA,
ATU or A?
ATA,
ATA XI
Why?
Y.
XIY. After completing her SSC in the year 2020 from Gujarath board, she cleared her 12th standard in March 2022 as evident from the mark sheet and passing certificate annexure C. Para. Inclined to pursue higher study in medical stroke paramedical, she opted for Group B in science stream in standard 11 and 12. Stop. And after passing the same, she appeared for the examination, qualifying for obtaining a seat in medical stroke paramedical known as quote National Eligibility Cum Entrance Test bracket UG bracket close for the year 2022 and successfully passed the said test after passing of the NEET test. She underwent medical test for All India seat before the notified center.
At the All India
At-
Institute.
At
AIIPMR at Mumbai.
Page 34.
which is that
All in
Page
page
34.
All India Institute of Physical Medicine and Rehabilitation bracket open AIIPMR capitals bracket close comma Mumbai. for medical test, and after being examined by the medical board, she has been assessed with a disability of at 47%. She has also been certified to be eligible for medical studies. And eligible to claim P capital, W small, D capital reservation as per NMC bracket mein, as per NMC norms. It is claimed by the learned counsel appearing for the petitioner that accordingly she has appeared and has been declared successful and granted admission to MP Shah Medical College, Jamnagar, Pandit Nehru Marg, Jamnagar, Gujarat State, and allotted a seat in the said college. What is GN PWD means?
That is a general category permanent persons with disability.
Under the category, quote and unquote, GN PWD. Hence, contending that she cannot be deprived of a seat under the state quota, has approached this court by raising several contentions. Since the selection process had commenced, we had issued a short notice on 19th and ordered the matter for listing today. And at the commencement of the hearing, the above said admission accorded by, this is by this,
Pardon?
All India.
This is by All India Medical.
accorded by the All India entrance to which the petitioner has been declared as being eligible, has been placed before us. At this juncture, the learned GP, Srimati Manisha Laukumar, would submit that without prejudice to the contentions that would be raised in the present petition, and in the peculiar facts and circumstances that have unfolded, namely where the petitioner has been declared to be eligible for being medical course, for pursuing her medical course, and to claim PWD reservation, notwithstanding the negative certification issued by the medical board of the state of Gujarat and approved by the appellate authority, the state would still consider the claim of the petitioner under which category? GNPW.
Same
Under
PWD
GN
quota, state government quota.
Under open state government quota
General PWD.
in GN space PWD in the ongoing process for admission, and the outcome of such consideration would be placed before this court on the next date of hearing. Full stop. Her submission and undertaking placed on her submission and undertaking made on instructions is placed on record. For reply statement and for further orders, release this matter on
Any date of reopening.
10th, second week, 10, 10, 10, 11.
Would my lord add one sentence? When my lords noted that in view of the peculiar circumstances of having been found eligible by the All India Medical Board and having secured admission in the All India quota.
Having been declared.
Yes, eligible. My lords have noted this, having been declared eligible
And having secured
and
admission.
having secured
All.
on All India quota.
Lordships may kindly say that I place on record this because
Yes, yes, lordships have stated.
no, otherwise.
It is stated.
Twice we have said that twice,
Sorry,
two
sorry,
places.
It is.
I'm deeply obliged, my lord.
Here, written back at the beginning.
The original we have.
Which name? Photocopy we have retained.
That's
Deeply obliged.
reasonable. Grateful to you.
Tomorrow, who knows, she may become a Nobel laureate,
Absolutely.
and
We hope
she
so.
will, and she is from state of Gujarat, and she will remember Monisha Lakuma.
You will remember my lords.
No, no.
With the graceness to my learned friend to the court, in the first matter, the girl was hardly having 171 marks in NEET. That is minimum 135. People are 690 are not getting. She got it, and in the first semester examination, she stood third in the BJ Medical. So
All.
I think almost all friends.
Lord, item.
I have dedicated my life to this spastic. I am a father of a girl, 35 years suffering from blood cancer and spastic. So I am doing this litigation for those children.
All.
I'm thankful to the court.
No, we appreciate your large-heartedness, Mr. Counsel. Only we wish better future for your child.
She survived medical science said she hardly survived for 3.5 months in 2014. All MPs are cancer and private doctors. The God is there. She is surviving after 9 years. Though I have to take care. So normally, almost all judges know as soon as my matters are over, I am leaving the court to spend time with her. Sorry for that.
No, no.
This earlier matter, the present Attorney General, Mr. Venkatramani.
We have a meeting, all our
One
brothers and
minute, I'll
sisters
take.
are.
The present Attorney General Venkatramani was to appear online in the earlier matter.
Okay.
He had sent some judgment also about 30-1.
Okay.
But anyhow, the matter was sorted out. I'm happy with that.
Lord, item.
Apologies because I was not here.
Ah.
Can it be on reopen?
Which one?
The tender matter.
Serial number?
Serial number 3 below.
All. 10th.
Lord, item. Item
Sorry.
19.
On 10/11, yes.
Obliged.
Lord, item 19, my lord. There is some urgency, my lord. Can it be on 7th? There is a stay against us, my lord, and there is suppression of material fact, my lord. We filed our reply. The court directed us to file our. It's item 19. The next.
All. Public interest litigation.
Yes, my lord. There is, your lordships have granted a stay, my lord, against the ropeway. There is a notification issued under section 10 of the Bombay.
All.
There is suppression, my lord, and there is an alternative remedy also available, my lord.
13/11.
13/11 is Sunday, my lord.
Sorry. 14/11. 14.
Very. My lord, not possible in the first week, my lord. 8th,
We have
9th.
listed too many matters, Shalini. Your matters only 3 or 4 we have listed. You know.